Hey, have you ever wondered how it is that the Supreme Court came to be seen as a distinctly political body, despite its clear constitutional role to be expressly non political? Well, that is precisely what we are going to be talking about today, and I assure you, whatever you think you may know, you're probably wrong. Hey, greetings, and welcome back once again to Categorical Imperatives. As always, I am your host, Lockie and Liberal, and thank you so much for being here with me today. For those of you who may be new to the show, welcome. This is a podcast where we are going to be using legal and moral philosophy to discuss current events as they relate to various aspects of politics and culture. And I don't know about you, I'm feeling pretty good today. I just found out that Justin Amash will indeed be running for president on the Libertarian ticket, so I am pretty happy about that. Also, we've got a great show for you here. This is going to be a really interesting one. As I said, the Supreme Court is often seen today as a distinctly political body, despite the fact that it is not, and the fact that it was not meant to be in the Constitution. So, how did this happen? Well, Franklin Roosevelt was elected president in 1932, and his New Deal policies aimed to reform the entire American economy. During Roosevelt's first and second terms in office, the Supreme Court radically altered how it reviewed regulations of economic liberty. However, even to this day, many lawyers do not know why and when this change actually occurred. And as a matter of fact, our story starts before Roosevelt even took office. And it starts in February of 1930 when Chief Justice Taft resigned from the Supreme Court due to illness. And 1 month later, Justice Sanford suddenly passed away. And Herbert Hoover nominated Charles Evans Hughes and Owen Roberts to fill those two vacancies. And though Hoover was a Republican, he was a political progressive, and his two appointments began to shift the court to the left. And we start today with a case known as O'Gorman and Young versus Hartford Fire Insurance Company. This is a case from 1931. And in this case, Justice Roberts made an immediate impact on the court in O'Gorman and Young because under the New Jersey law, the Commission on the Sale of Fire Insurance Policies are required to be reasonable. And the O'Gorman firm sold Hartford in fire insurance policies, and their contract provided that the commissions would be priced at what such services were reasonably worth. Now, O'Gorman asserted that its commission was reasonably worth 25% of the insurance premium. Hartford, however, only paid 20%. And O'Gorman filed suit for breach of contract, and the trial court found that under the New Jersey law, a 25% commission was unreasonable and could not be paid. So O'Gorman appealed this case all the way up to the Supreme Court, and the firm argued that the regulation deprived the company of property, being the extra commission that they were owed, said that they felt they were owed at least, without due process of law. And in April 1930, the court heard oral arguments. At the time, there were only 8 justices on the bench, and apparently the court split 4-4 on whether the regulation was constitutional. So 3 weeks later, when Justice Owen Roberts was confirmed, O'Gorman was actually re-argued the following term, and at that time, Justice Roberts cast the 5th and deciding vote to uphold the statute. Now, the Supreme Court precedent, which included Lochner, which is a case I've covered in the past, Great case. I recommend you go back and check out my video on Lochner v. New York if you have not seen it before. In fact, I'll put a little link to it in a card in the upper right-hand corner right now. Anyways, so the Supreme Court precedent, which included Lochner, recognizes that the 14th Amendment protected the liberty of contract. That right generally prohibited price regulations, but there was an exception to the general rule. Legislators could set prices for a business affected with a public interest. Originally, this category was limited to businesses with some kind of monopoly market power. Eventually, though, the Supreme Court expanded the category to include any business the state wanted to regulate. And Justice Louis Brandeis wrote the majority opinion in O'Gorman, and he found that the business of insurance is so far affected with a public interest that the state may regulate the rate. And this was to avoid the evils of an unreasonably high rate level. The state may limit commissions. Therefore, the New Jersey statute is clearly within the scope of the police power. Second, Justice Brandeis explained that the court must presume the law is constitutional unless there is a factual finding on the provision that it was not an appropriate remedy for the evils in the insurance industry. Hence, the court applied a presumption of constitutionality, and that nothing on the face of the New Jersey statute or the facts of which the court must take judicial notice, he wrote, could rebut this presumption of constitutionality. Therefore, he concluded, this regulation was reasonable. And Justice Van Devanter wrote the dissent. He was joined by Justices Sutherland, Butler, and McReynolds. And while the majority presumed that the law was constitutional, the dissent required the government to justify why the law is necessary. Justice Van Devanter's dissent offered the following test: that the state could deny O'Gorman the right to make private contracts only if some special circumstances exist that are sufficient to indicate the necessity of a statute to eliminate evils in the marketplace. The keyword here, of course, is necessity. And next we move on to a case known as Nebbia versus New York from 1934. And 3 years after O'Gorman was decided, the court considered another economic liberty case. This was Nebbia v. New York, and the state fixed the price of milk at 9 cents per quart. The law, which was designed to help dairy farmers, raised milk prices for everyone, including the poor. Now, the biggest beneficiary of the law, however, were large firms that delivered milk directly to homes, and their prices could be undercut by the small mom-and-pop stores that did not have to incur delivery costs. And in this way, the minimum price for milk protected the profits of large milk distributors. And so, grocer Leo Nebbia offered his customers a special deal to get around the New York law. If a customer bought 2 quarts of milk at the regulated price of 9 cents each for a total of 18 cents, Nebbia would throw in a free loaf of Italian bread, which was worth 5 cents. So with this deal, customers were receiving 23 cents of groceries for only 18 cents. And New York charged Nebbia with violating the price control law. He was convicted of offering his customers a discount and was settled to pay a criminal fine. Sorry, that line is so absurd to me. He was convicted of offering his customers a discount. I'm sorry, I'm going off script here, but it's just that is such an absurd idea. He was convicted of offering his customers a discount. What a terrible person he is. Anyway, sorry. Nebbia argued that the law deprived him of liberty and property without due process of law. The Supreme Court rejected his argument by a 5-4 vote, and once again, Justice Roberts was the swing vote. This time, he authored the majority opinion, and first, Justice Roberts wrote that grocery stores can regulate businesses affected with a public interest, and the category now included even the corner grocery store. As a result, the states have the police power to fix the prices to be charged for the product or commodities that the store sells. And second, the court reviewed the New York law with the presumption of constitutionality that had been articulated in O'Gorman. And under this approach, the state was free to adopt whatever policy may reasonably deemed to promote the public welfare. The requirements of due process were satisfied, Justice Roberts observed, if the law had a reasonable relation to the proper legislative purpose and was neither arbitrary nor discriminatory. He said it was not the court's role to determine if the rule was unwise. Now, third, the court considered how the law accomplishes his purpose, and this is the relationship between the means and the end. What evils was the government trying to address? As was ruthless competition from destroying the wholesale price structure on which the farmer depends for his livelihood. The court concluded that the price control law was not unreasonable or arbitrary, and it had a relation to this purpose. Therefore, Nebbia's conviction was proper. So, as they had in O'Gorman, Justices Van Devanter, Sutherland, Butler, and McReynolds dissented together. And as you know, in O'Gorman, the quartet had rejected the presumption of constitutionality, and in his dissent for Nebbia, Justice McReynolds observed that the stated purpose of the New York law was to increase milk prices at the farm. Yet, the distributors were not required to share their increased revenue with dairy farmers. And so, for this reason, he questioned whether the means adopted being the price controls for a reasonable relation to the stated purpose of assisting dairy farmers. Justice McReynolds did not assess the legislator's motives directly. Instead, he concluded that the law is arbitrary because the means adopted did not fit the purported ends of the legislation. In other words, the law seemed to be designed to protect large milk distributors from competition rather than to help farmers. Now, between 1931 and 1937, Justices Van Devanter, Sutherland, Butler, and McReynolds consistently voted as a bloc to declare unconstitutional progressive federal and state legislation. In fact, this conservative quartet had come to be dubbed by their critics as the Four Horsemen. This is, of course, a reference to the Four Horsemen of the Apocalypse from the New Testament book of Revelations. During the same, Justice Roberts was often the swing vote. In some cases, he would join with the Four Horsemen to give the conservative majority a win. In other cases, like in Gorman and Nebbia, Justice Roberts voted to uphold progressive legislation. And in our next case, West Coast Hotel versus Parrish, we find Justice Roberts once again joining the liberal bloc. So, West Coast Hotel versus Parrish is a 1937 case. In this case, Washington State imposed a minimum wage for women and children, but not for men. Elsie Parrish worked as a chambermaid at the West Coast Hotel in Wenatchee, Washington. Her employer failed to pay her the minimum wage, and she filed suit to recover back pay. The hotel's owner argues that the labor regulation deprived him of the liberty of contract without due process of law. Over the previous 3 decades, the Supreme Court had decided several cases concerning economic liberty for women. In Muller v. Oregon in 1908, the court upheld a law that limited the hours women could work. This law was deemed reasonable because of the physical differences between men and women. However, 15 years later, in Atkin v. Children's Hospital in 1923, the court declared unconstitutional a minimum wage law for women. the federal statute violated the liberty of contract protected by the Fifth Amendment's Due Process Clause. And 13 years later, in Moorhead v. New York in 1936, the court reaffirmed Adkins. In this 5-4 decision, they found that the New York minimum wage law for women was unconstitutional. Now, in this case, Justice Roberts joined with the Four Horsemen. Critically, however, in Moorhead, the court was not asked to overrule Adkins. But in West Coast Hotel versus Parrish, they expressly asked the court to overrule Adkins. And by a 5-4 vote, the court did exactly that. Justice Roberts once again cast the deciding vote, and Chief Justice Hughes and other Hoover appointees wrote the majority opinion. He explained that Adkins, decided only 13 years earlier, was a departure from the true application of the principles governing the regulations by the state of the relation of employer and employee. Furthermore, cases since Adkins, including O'Gorman and Nebbia, applied those principles properly through the presumption of constitutionality. Chief Justice could not reconcile Adkins with Gorman and Nebbia, and therefore the court overruled Adkins. So, with Adkins out of the way, it was easy for the court to uphold the Washington minimum wage law. If the protection of women is a legitimate end of the exercise of state power, Chief Justice Hughes asked, how can it be said that the requirement of the payment of a minimum wage, fairly fixed in order to meet the very necessities of existence, is not an admissible means to the end? He added, even if the wisdom of the policy be regarded as debatable and its effects uncertain, still the legislature is entitled to its judgment. And this deference is especially appropriate, the court noted, in light of the unparalleled demand for relief which arose during the period of the Depression. Therefore, the law did not violate the 14th Amendment. And for one last time, the Four Horsemen dissented together. Justice Sutherland, who wrote the Adkins majority opinion, also wrote the West Coast Hotel dissent. Here he questioned the presumption of constitutionality. The dissent explained that a judge had an independent duty to make up his own mind and judge accordingly whether the law is constitutional. A differential judge who automatically accepts the views of others, he lamented, has surrendered his deliberate judgment. Justice Sutherland further contended that the court should not base its ruling on the exigencies of the Great Depression. The meaning of the Constitution, he stated, does not change with the ebb and flow of economic events. Rather, he added, the words of the Constitution must mean today what it meant when it was written. A contrary rule would rob that instrument of the essential element which continues it in force. Finally, Justice Sutherland attacked the law because it imposed a minimum wage for women, but not for men. Now, as a senator, Sutherland had supported the 19th Amendment and women's suffrage. In his dissent, he stated that women today stand upon a legal and political equality with men, that therefore differences of sex are no reasonable ground for making a restriction applicable to the wage contract of all working women, in which contracts of all working men are left free. Now, on March 29th, 1937, Justice Roberts joined the majority opinion in West Coast Hotel, which overruled Adkins. However, only 9 months earlier, in Moorhead, Justice Roberts had agreed with the Four Horsemen that the New York minimum wage law for women was unconstitutional. In light of Adkins, How can we explain his change in position? Well, 4 generations of students have learned that Justice Roberts changed his vote in response to President Franklin Roosevelt's proposal to expand the size of the Supreme Court. On March 9th, 1937, 3 weeks before the decision in West Coast Hotel, he announced his so called court packing plan, in which he explained,
"What is my proposal? It is simply this. Whenever a judge or justice of any federal court has reached the age of 70 and does not avail himself of the opportunity to retire on a pension, a new member shall be appointed by the president then in office with the approval, as required by the Constitution, of the Senate of the United States."
Now, the size of the Supreme Court is not specified in the Constitution. It has always been set by Congress. The number of justices has varied from as few as 6 to as many as 10. Now, President Roosevelt was not concerned with the age or the workload of the court. Rather, he was frustrated that conservative justices had declared unconstitutional federal and state progressive legislation. President Roosevelt called upon Congress to change the size of the court for a very specific purpose of appointing new justices who would be more amenable to his New Deal policy agenda and his vision of the Constitution. So on March 29th, 3 weeks after the president's announcement in West Coast Hotel, Justice Roberts wrote the majority his apparent reversal from Moorhead. His apparent reversal from Moorhead, created the appearance that the court packing proposal had actually influenced his decision. According to what has been the conventional narrative, Justice Roberts voted to uphold the Washington minimum wage law in order to remove the incentives for President Roosevelt to pack the Supreme Court. And since that day, Justice Roberts' vote has been hailed as the so-called switch in time that saved 9. This is, of course, a play on the aphorism that a stitch in time saves 9. In other words, if you mend a small hole now, you won't need to mend a bigger hole later. However, the conventional narrative that Justice Roberts changed his vote in response to the court packing plan has now been called into question because in 1936, several of the justices recorded the votes cast at a private conference, and this is based upon the records in the docket book. We happen to know for a fact that Justice Roberts had voted to uphold the Washington law in December of 1936. This is nearly 3 months before President Roosevelt announced his court packing plan. So, there is really a far more mundane explanation for Justice Roberts' switch in Moorhead, because the court had not asked to overrule Adkins. However, Elsie Parrish had expressly asked the court to overrule Adkins. And so it did. And essentially, this was relying on prior decisions that Roberts had joined, including Gorman and Nebbia. So why does this all matter? The reason this history matters is because, according to the conventional narrative, Justice Roberts changed course for political reasons. Therefore, the argument goes, the Supreme Court is an inherently political institution. And because the conventional narrative applauds the switch in time, a political Supreme Court came to be seen as a good thing. The actual history, however, reveals that the politics played a very different and much more subtle role. The fact is, Herbert Hoover appointed a political progressive. He appointed two political progressive, Chief Justice Hughes and Justice Roberts. These appointments, unsurprisingly, moved the court in a progressive direction. Hughes and Roberts simply had different judicial philosophies about the Constitution than those held by the more conservative justices who had comprised the Four Horsemen who had been appointed by conservative presidents. In this way, popular elections and not intimidation by political actors changed the constitutional balance of the Supreme Court. The political process by which judges are selected allows a justice with one principal vision of a constitution to be replaced by a justice holding a different vision. So, West Coast Hotel was a byproduct of Herbert Hoover appointing progressive justices in 1931. It had nothing to do with President Roosevelt's partisan tactics in 1937. So, West Coast Hotel marked the commencement of what is sometimes called the Constitutional Revolution of 1937. And this is actually something that I have discussed in two past videos where I talk about the 14th Amendment and the incorporation doctrine and the myths that surround those. Many people think that they played a large role in the Constitutional Revolution of 1937. They did not. If you want to learn more about that, I will be putting a link, a little note up in the corner in the right-hand side now that will link you to those videos. And I'll put a link down in the description of this video as well if you want to check those out. They're generally great videos, and they do tie into what we're talking about here today. However, all that aside, whenever and however it happened, there is no dispute that a constitutional sea change did in fact occur. Recall that during the same period, the Supreme Court also approved a vast expansion of Congress's powers under the Commerce and Necessary Proper Clauses. And again, this is something I have talked about in my video about Lochner v. New York. I go into great detail about the expansion of implied powers under the Commerce and Necessary Proper Clause. I'll be putting a link to that in the description as well. Now, 3 months after West Coast Hotel was decided, the Four Horsemen essentially disbanded. In June of 1937, Justice Van Devanter retired. In January of 1938, Justice Sutherland retired. Justice Butler stepped down the following year in November of 1939. Finally, 13 months later, in January 1941, Justice McReynolds left the court. So, during his 12 years in office, President Roosevelt made 9 Supreme Court nominations. So, by 1933, during Roosevelt's unprecedented fourth term in office, he had replaced all members of the once conservative court from the progressive era. So, throughout the New Deal, starting with Gorman in 1931, a constitutional sea change had occurred, and soon even more radical changes would come. Throughout the New Deal, the presumption of constitutionality that we find in O'Gorman and Nebbia and West Coast Hotel was still rebuttable. It was still feasible for a plaintiff to challenge the constitutionality of a law that restricted economic liberty. This is also something I've talked about in my last video, U.S. v. Lopez. I talk about how this history plays a big role in the expansion of applied powers. So I guess I'll be putting a link to my U.S. v. Lopez video down in the description as well. But to wrap up here, they could present evidence showing that a restriction was arbitrary. Eventually, however, as the court progressed from the New Deal court to the Warren court, the presumption of constitutionality was no, it became entirely reputable, and the dissenting opinion that it was incumbent upon the government to prove constitutionality died off. And so it was with this, when the Warren Court would finally begin to make this presumption of constitutionality as reputable, that the constitutional revolution was completed. Well, that will do it for today. I want to thank everyone for watching the show. I hope you like this a lot. If you do, please take a moment and subscribe to the channel. I'm not putting videos up on a regular schedule right now, which I like to do eventually. But in the meantime, subscribe to the channel. That way you will get notifications when I post new videos. I would really, really love to hear what you guys think in the comment section below. What do you think about this history, about the Supreme Court, about the Constitutional Revolution of 1937? I guess the big question is, do you see the Supreme Court as a political body? And does this information change your opinion about that in any way? I would really love to hear what people think about that. And then finally, something I just always ask people is, if you like this episode, please take a couple minutes and just pass it on to one or two people who you think might also enjoy hearing this message. And if you would do that for me, I would really greatly appreciate it. So this has been me, Lockean Liberal, for Categorical Imperatives, talking about the Supreme Court and the Revolution of 1937. And as always, Delenda es Carthago.